The Supreme Court, in a ruling that shocked many today, upheld President Obama's health care law. The centerpiece of that law, the individual mandate, being upheld as a tax. Chief Justice Roberts wrote the majority opinion. In part, he wrote the Affordable Care Act's requirement that certain individuals pay a financial penalty for not obtaining health insurance may reasonably be characterized as a tax. Because the Constitution permits such a tax, it is not our role to forbid it or to pass upon its wisdom or fairness. Now, in the dissent read by Justice Kennedy, who was believed to be the swing vote, and here he sided with the dissent in a joint dissent, in part, to say that the individual mandate merely imposes a tax is not to interpret the statute, but to rewrite it. To say, and he goes on to say, judicial tax writing is particularly troubling. So let's bring in our expanded panel tonight. Judge Andrew Napolitano, Fox News senior judicial analyst. Jeff Zeleny, national political correspondent for the New York Times. A.B. Stoddard, associate editor of The Hill, and syndicated columnist Charles Krauthammer. Okay, Judge. Your thoughts?
This is the jurisprudential equivalent of driving a camel through the eye of a needle. That's the circuitous route through which the majority took the law in an effort to justify it. In the very phrase in which the majority calls it a tax, it refers to it as a penalty. The Constitution requires a tax to emanate in the to start in the House of Representatives. This didn't. The Constitution says that a tax is used to generate revenue. This is used to punish. I think that this is not a decision that will be well regarded by legal scholars, that it was result-oriented, not process-driven.
Jeff, a huge victory for the Obama administration?
I think in the short term, it definitely is a huge victory for the Obama administration because it takes away the ability for Republicans and critics to sort of brand him as a failed leader, a Jimmy Carter, if you will, that he spent all this time on this and it failed. But it's not necessarily a clean case. I mean, he cannot talk about health care from here forward until the election day. That's not a winning strategy, and they realize that. I mean, this election is still about the economy, but it's been a tough month for this White House, for this administration, so I think it ends probably better than most anyone there would have assumed it would be, at least in the short terms of the politics. But it introduced a new argument here against him, a tax argument, so he'll have to respond to that. It's something that he's on record saying it's not. He said this was not a tax, so it's a new line of attack.
A.B.
I think that's true. I think that President Obama dodged an enormous bullet with this ruling. The stamp of failure would have been so significant that would have been really hard to overcome. He has an opportunity to resell the law. He didn't do it the first time well. I don't know that he'll do it the second time well. There is a new line of attack, as Jeff says, a new campaign Republicans can open up against a new tax. It will be harder to win the war, but he won the battle today.
Charles, why Chief Justice John Roberts wrote the majority and sided 5-4 with the liberal wing of this court? You have some sense about why that happened?
I think it was, as the judge says, result-oriented. And the result he wanted was this. Roberts did not want to uphold the liberal argument in support of Obamacare, which was that you can impose the mandate because it would be okay under the Commerce Clause. As Roberts wrote, that clause allows the government to regulate commerce, but it surely doesn't allow you to impel or compel commerce, which is what it would do, compel you to buy health insurance. So he didn't want to accept that. And you would have thought he therefore would have overturned the law. But he didn't want to overturn the law because as Chief Justice, he feels he's the custodian of the reputation and the stature of the court. And I think he thinks that the court suffered in the decision in 2000 and Gore and Bush was seen as a partisan court. It went 5-4 along ideological lines, and he was afraid if that happened on Obamacare, it would diminish the standing of the court, which he thinks he's responsible for keeping it up. So he concocted this finesse which allows him of calling a mandate a tax, which it is not. So he concocts a finesse which allows him to uphold the law and strike it down, the Commerce Clause, as the reason for it.
What about this expanded Medicaid portion that was not upheld?
Well, you know, that is a 7-2 vote. And that is basically saying that the federal government cannot coerce the states into doing something they otherwise wouldn't do. It can invite them, it can entice them, it can compensate them, but it can't coerce them. And the coercion here was very, very severe. The coercion in the statute said, if you don't set up these insurance exchanges by expanding Medicaid to people who don't otherwise have or can't otherwise acquire health insurance, you will lose all your Medicaid reimbursement, not just the Medicaid reimbursement that we will give you to assist you in setting up the exchanges, but all of it.
Right, those were the strings that Congress tied.
Correct. That was so heavy a burden, the majority felt, 7-2 majority here, that it amounted to coercion. And coercion against the states by the federal government has been theoretically outlawed for years.
Well, you've read this thing a couple times now.
Yes.
A quick question. We talked about it with Jonathan Turley and Paul Rothstein. What about a precedent-setting aspect to this? That, okay, it's not, the mandate is not constitutional as through the Commerce Clause, but it's a tax. So couldn't the federal government then say you have to buy something, and then if you don't, tax them?
Precisely. This is why Charles is exactly right. Charles sounded like he has a JD as well as an MD. I mean, I think that the Chief Justice, either wittingly or unwittingly, has created for the Congress a vast new area of almost unlimited power to regulate private individual behavior by taxing the individual who doesn't do what the Congress commands and not even referring to it as commercial in nature.
Jeff, the Solicitor General probably breathing a sigh of relief after all of the criticism about his oral argument. It seemed like court watchers were wrong in how his presentation went.
I think there's no question that they were wrong, although his argument was not accepted by the justices. I mean, so he wasn't exactly making the argument that was the final outcome here. But look, I mean, I think if you talk to the real court watchers, the handful of reporters and lawyers who are in the chambers for most of the hearings, they say it's totally common for the SG to be interrupted. It's totally common for him to sort of stammer a little bit. So I think a lot of wrong analysis was coming out at the very beginning of those arguments, because it's an entirely different case now.
It's a lot of digesting. The politics of a mandate as a tax, next.